Excellent. So today's Thursday. So Tuesday, so earlier this week, we wrapped up with the due diligence period and the earnest money. Taylor, did anything come up for you? Any questions come up for you after going over this?
No.
Okay, perfect. So we'll just launch right into it. So 9 talks a little bit more about lead-based paint. So on the first page, you've got where I wish I could do split screen, but I can't. That's too much technology. So on 9, we'll take a look at this again. Lead-based paint, you're checking off if it was or was not built prior to 1978. And then we've got these brokerage boxes here in material. So we're going to go back to 9. And that's basically what it says. If any portion of the dwelling was built prior to 1978. Um, includes any painted fixture or material used therein. So just like you mentioned earlier this week, if you got the mantle, if you got all of the fun doors and doohickeys and doodads inside the house, just for CYA purposes, you're going to want to have the lead-based paint attached. So brokerage relationships, this just I'm not going to read all of this. This basically just goes into more detail. I'm going to look at the first page again. So again, like we mentioned, if we're representing the buyer, we're on the left side, A. If we're representing the seller, then they're going to fill out Keller Williams Elevate is what we're going to put on there, not teams, not anything along those lines. It's truly the agency name. Um, and if we're representing them as a client, as a client, if we're representing either side as a customer, acting as dual agency, that typically doesn't happen that often. I can't say I've really seen it in a really long time, but definitely something I want to stress is that if anyone, because right now we're still tethered with Woodstock, so it's Keller Williams Realty Partners across the board. If you encounter anyone with Keller Williams Realty Partners, that office specifically, you do have to check the boxes number 4 on each side, and then you write your name on whichever side you're on, seller or buyer, and you're writing the other party's name in there as well. So Taylor, you're writing an offer on one of my listings. Your name is on the A side left, and my name is on the B side on section 4. Material relationships. That I wonder if they go into that a little bit more. Sorry. C, disclaimer. Okay.
On that, am I selecting 1 and 4?
Nope, you're just
Um,
selecting
just 4. Okay, so it doesn't matter if it's a customer or client at that point.
right. We
Okay.
just select 4. I've never had it kicked back from compliance. That's a great question. You could probably select both, but I know we've always selected just 4.
Okay.
Um, okay, so material disclosure, buyer and seller have not relied upon any advice or representation of broker other than what's included in this agreement. Brokers shall have no duty to determine whether the identities of buyer and seller are legitimate. Inspect the brokers. Okay. Disclaimer. Interesting. I wasn't expecting this paragraph to go in this direction. So broker shall have no duty to determine whether the identities of the buyer and seller are legitimate. We have no duty to inspect the property for defects, hazardous conditions, repairs, or any other matter. And we have no duty to advise buyer or seller on any matter related to the property, which could have been revealed through a survey, appraisal, title search, etc. Um, gosh, all these different tests. This is a great this is a great paragraph to reference. What kind of test should I get? Well, you can get synthetic stucco, mold, asbestos, lead-based paint, etc. Um, we have no duty so again, the beginning of the sentence says has no duty to determine or has no duty to review of this agreement or transaction by an attorney, financial planner, mortgage consultant, or tax consultant, and consulting appropriate government officials, zoning, propensity. This is basically a CYA. Georgia is a buyer beware state, very much so. Um, this is our get out of jail free card in the sense of a just disclaimer. Buyer and seller acknowledge that broker does not perform or have expertise in any of the above tests, inspections, or reviews in any of these matters handled by professionals referenced above. Buyer and seller shall seek independent expert advice regarding any matter. Broker shall not be responsible to monitor, supervise, or inspect any construction or repairs. Buyer further acknowledges that broker has no duty to ensure that seller has terminated. Broker has no duty to ensure that seller has terminated those third-party administrative access to devices, so like Wi-Fi. Okay, interesting. If broker has written any special stipulations herein, the party for which special stipulations were written confirms that each stipulation reflects the party's complete understanding, adopts each special stip as the original work of the party, and hereby agrees to indemnify and hold broker who prepared the stipulation harmless for any. Okay, that's nice. Buyer acknowledges that when and if broker answers a question of buyer or otherwise describes some aspect of the property or the transaction, broker's really doing it based on the information provided by the seller rather than the independent knowledge. This is the most perfect CYA paragraph ever. I just wasn't expecting it to go like this. So this is kind of very similar to the listing agreement and the buyer agreement where we're like, hey, we're not an expert in all areas. You really need to go to like a CPA or an attorney or a financial planner. That's fine print and part of the purchase and sale agreement, and I am here for it. I love that. What I was expecting, let me go back up to it, was 10 ABC, material relationships required to be disclosed by either broker. That's what I was expecting, where it's spelled out. No, it's A, B, and C. No, it doesn't. It does not spell out. This is hey, if it's a third cousin twice removed, etc., babysitter, like you don't have to disclose that material relationship. I was expecting it to go in more in depth of that, of what they constitute a material relationship. I thought they had done that in the past, so I guess that's what I was expecting to read. So my fault for not reading the contract in a minute. That's interesting. Time limit of offer, we discussed that a little bit last week or earlier this week of it's really going to be a case by case and a market by market situation. I still, when I write offers as of right now, September 2024, I am putting in a deadline. I don't want you to just sit on it. We would like to have some answers. That's the most stressful time a buyer is going to go through is what did the seller say? Okay, so section C. So we had the A section, the B section. Now we're into the C. Notices, all notice given herein shall be in writing, legal. There is a notice form. If you just go into the GAR docs and type in notice, there is a specific notice form. In the event of dispute regarding the notice, the burden shall be on the party giving it notice to provide proof of delivery. And in the notice, it does say, how are you delivering it? In person, courier, email, fax, etc. And you just check off that box. A notice to a party shall be deemed to be delivered and received upon the earliest of the following to occur. Actual receipt in case of delivery. So this just goes more into depth. I'm not going to read through that. When broker is authorized to accept notice. So except where the broker is acting as dual agency, the broker and their license representing their party shall be authorized agent of the party for the limited purpose of receiving notice and such notice. Notice to an authorized agent shall be effective if the written notice is sent to an address, fax, or email. Whether it is opened by them or not. So the act of me sending it. So Taylor, I am sending you notice. It's on a form and I've emailed it to you. I've emailed it using the email address as part of the MLS, or maybe part of the binding contract. And I have no control over whether it hit your spam or if you even opened it. But the fact that I sent it to you, it didn't bounce, and I can prove that I've sent it to you is enough for providing notice. Except as provided the broker's staff at a physical office set forth herein of the broker are authorized to receive notice by delivery service. So this just obviously goes a little bit more into depth about that. And I'm going to repeat. So I'm representing my client as a seller. So I don't have to show that I gave notice to the seller. Just receiving the notice from you is basically providing notice to the seller. It qualifies. Okay, default. In the event this amendment fails to close due to default of the buyer, seller's sole remedy shall be to retain the earnest money as full liquidated damages. They waive any right to assert claim for specific performance. The parties expressly agree that earnest money is reasonable pre-estimate of the seller's actual damages, which damages the parties agree are difficult to ascertain. Parties expressly intend for the earnest money to serve as liquidated damages and not as a penalty. What we're going to discuss is they're trying to avoid taking it to court. So that's a huge thing when it comes to representing a buyer. You're like, I just want to be able to throw as cheap as possible earnest money, up front, because it's possible to lose. Whereas the seller on that side, they need to be comfortable with whatever earnest money that the buyer's presenting or counter, such that if the buyer defaults, they're not like, dadgummit, $1,200 was absolutely not enough to keep me off the market for 2 months and yada, 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 yada. So it really needs to be, we're holding the buyer's feet to the fire to perform by the terms that they agreed on the contract. So that's something to think about. In the event the agreement fails to close due to default of the seller, buyer agrees to seek the specific performance of this agreement or terminate upon notice, again, the notice form, in which case all earnest money deposits and other payments buyers made towards the purchase shall be returned to buyer following the procedures. And, oh, look at that last line, and buyer may pursue any other remedy available at law. In the event this agreement is terminated and fails to close due to default of a party, the defaulting party shall pay as liquidated damages to broker in this transaction the compensation the broker would have received had it closed. For purposes of terminating the amount of liquidated damages, all written agreements establishing the amount of compensation to be paid shall be incorporated. Liquidated damages are reasonable pre-estimate and are not a penalty. Okay. If any litigation or arbitration included but not limited to breach, the non-prevailing party shall be liable to the prevailing party for their fees and expenses. So again, this is the fine print of the contract that people are signing off on, and they don't realize their feet can be held to the fire. This is timely. Risk of damage to property as we're about to go into the storm. Seller warrants that at the time of closing, the property and all items remaining within the property shall be in the same condition as of the offer date. I actually had that wrong. I thought it was the binding date, but as of the offer date, except the changes made, based on the amendment. At the time of possession, seller shall deliver property free, clean and free of trash, debris, and personal property of the seller not identified as remaining with the property. You go to a walkthrough and you're left with junk, you call that listing agent and you say, hey, this is a violation of the purchase and sale agreement, section C, number 3. I still have trash. I still have debris. I still have personal property at the property. Nope. Closing's not happening. Get your seller, or get, 1-800-GOT-JUNK and get them out at the property. That's in violation of this contract. So be mindful when you write a special stipulation, because you want it clean. Upon viewing the property, you're like, oh, this is not going to be good. I'm sure they're just going to get their stuff and go, and the house is going to be completely dirty. All it tells the seller is it's be clean. Everybody's level of cleanliness is different, and free of debris, etc. So you can, in your special stipulation, you really want to kind of go in more in depth. Brooms swept, or I want you to get a professional cleaning service to come out, or, cabinets are to be wiped down inside of cabinets and countertops and etc. So you kind of need to go a little bit more into depth. Okay. This is where it's timely. If the property is destroyed or substantially destroyed prior to closing, seller shall promptly give notice to buyer what happened and provide buyer with whatever information the seller has regarding the availability of insurance and the disposition of the insurance claim. Buyer or seller may terminate this agreement without penalty no later than 14 days of notice. If buyer or seller do not terminate, seller can cause property to be restored to substantially the same condition as of the offer date. The date of closing shall be extended until the earlier of either 1 year from the original closing date or 7 days from the date that the property has been restored to the same condition. And if applicable, a certificate of occupancy is issued. We're talking trees coming down on the property. We're talking about, we had an instance where I think we were representing the seller. I was an admin, and the seller had the washer and dryer, which was located upstairs, removed from the property prior to closing. The buyer, which is really weird because it was Cherokee County, Georgia, the buyer had somehow been able to have the water turned on. And whoever removed the washer and dryer upstairs did not secure and make sure that their water line that was connected to the washer was off. So for however many days, because it was an unoccupied vacant house, however many days that water was pouring into that house. And it wasn't discovered until it started to pour out of the house and into the cul-de-sac and down the street. And the neighbors were like, this is a problem. And it obviously from upstairs destroyed the house. So they got an insurance file claimed. The buyers wanted to stick around. They got to select, okay, we get new hardwood floors. Okay, I want to be part of that color selection. So they practically got a new house with all of the damage. But that's the one instance that still haunts me all these years later because it was very early in my career when all that happened. And yep, so they stuck around. Or again, the buyer has the option to terminate. So people ask that, like, what happens if the house is damaged in some way with a storm? It's pre-written in here. Okay, moving on. I can never really say this word. I want to say it's condemnation. Seller shall immediately notify buyer if the property has been subject to being condemned. And provide buyer with the notice as well. Buyer shall have the right, but not the obligation to terminate, refund earnest money, etc. Consent to share non-public information. They hereby consent to the closing attorney preparing and distributing the ALTA. Back when the ALTA went in effect, 2014, this was not in the contract, so we kept having to write it as special stipulations. And basically, it's just you allow us to have both sides see the ALTA, see the settlement statement, see the breakdown. Duty to cooperate. All parties agree to do all things reasonably necessary to timely and in good faith fulfill the terms of this agreement. Buyer and seller shall execute and deliver such certifications, affidavits, statements required by law, requested by attorney, mortgage lender, title, etc. Electronic signatures, we agree that, that's allowed. This agreement constitutes the sole and entire agreement between all parties. No representation, promise, or not included in this agreement shall be binding. Oh, well, they sent me a text. They wrote it by an airplane in the clouds. They pulled a banner behind an airplane. It doesn't matter if it's not in writing and part of this agreement. And we know in order to be part of this agreement after we go under contract is by an amendment. Any amendment to terminate this agreement any agreement to terminate this agreement or any subsequent agreement must be in writing and signed by the parties. Doesn't even say all, by the parties. This agreement may only be assigned or listed for sale in multiple listing service by buyer prior to closing with the written approval of seller. Any assignee obligation to pay the compensation. Okay. So like wholesalers, they can put it under contract and they have to get the seller to agree off on that the wholesaler is going to turn around and list it elsewhere. No time limit. under this agreement shall be extended by virtue of it falling on Saturday or Sunday or the fellow federal holiday, except for the date of closing. So basically, if your due diligence, financing, etc., falls on a Saturday, Sunday, or federal holiday, doesn't matter. It doesn't automatically get pushed to the next business day. You have to write a special stipulation. There are agents that will do that. Like if any of these dates fall on a Saturday or Sunday or holiday, it automatically, but without that stipulation, it doesn't, except for the date of closing. We don't close on Saturday and Sunday. It will automatically be pushed to the following business day. There we go. This is kind of that new stuff, unless seller is a foreign person, talking about that tax stuff. GAR forms, this is where, again, back to the listing agreement, buyer agreement. These are written by the Georgia Association of Realtors. No party is required to use them. They're generic, etc. Governing law. This agreement may be signed in multiple counterparts, each of which shall be deemed to be an original and shall be interpreted. No provision shall be interpreted less favorably. All references to time shall mean in the time of Georgia. Doesn't matter if you're signing it in Colorado. All right. No authority to bind. No broker shall have the authority to bind any party herein. Signed by broker, but not the party. Basically, even if we as the broker sign it, if it's not signed by the parties, the buyer or the seller, doesn't matter. It's not binding. Unless broker shall have the right to accept notice. Yeah. Additionally, any broker or real estate license involved in this transaction may perform the ministerial acts of filling in the binding agreement. Yep. In the event of dispute over the binding agreement, it shall be resolved by a court or arbitrator having jurisdiction or the holder, but only in making reasonable interpretation. These two pieces are huge and they're kind of new. The binding agreement shall be the date when a party to this transaction who has accepted it delivers notice of that acceptance to the party who made the offer or counteroffer. So the binding date shall be the date. So Taylor, you sent me an offer on Monday and we signed off on it Tuesday. It's the date. If I send it back to you on Tuesday and I deliver you back the notice on Tuesday, the binding date's Tuesday. I know that we went all over that all in real estate school, but they're just spelling it out a little bit more. Notice of the binding date may be delivered by either party. If notice of accurate binding agreement dates delivered, the party receiving notice shall sign and immediately return it. There's the book way, and then there's the realistic what happens way. And some people get caught up on, well, I don't want to fill in the binding date because I'm delivering notice to you and I need you to fill out the binding date and send it back to me. When you're in the field and you're actively working, so long as you'll start working with agents and we're like, yeah, we're both in agreement. You've got the contract in hand, just fill in the binding date and send it to me. Versus Taylor, you sending it to me, and then all of a sudden I have to fill it out and send it back to you. Just someone sign it, fill it in, just get us binding. That's what it's like out there in the trenches. I'm going to start having fun with that now. Because the book is like back and forth, back and forth. Okay, if I'm delivering notice, then you have to sign it, then you have to give it back to me. Just sign it is ultimately what it gets to. And I will say, objection to binding agreement date, I have been 100%. I've used this before, so it's funny that it's written in here. If the buyer or seller objects to the date entered in the binding agreement date, then they have within 1 day of receiving notice to object by sending notice to the party. The objection shall be resolved by a written agreement by both parties with executing a binding agreement date confirmation. The absence of an agreement on the binding agreement date shall not render this agreement unenforceable. The failure of a party to timely object will result in them accepting it as it's entered. That's again going back and forth, back and forth. Sometimes people write in the wrong days, and then they send it out and they don't realize it, or they write in the day and then they sit on it for a day and then they don't they don't send it out until the following day. Well, no, you didn't, Taylor, you didn't email it to me until the 24th. You wrote in the 23rd, but you didn't even bother to send it to me until 6 p.m. on the 24th. I'm not accepting the 23rd as a binding day. So again, we had that day. We have one day to object to it. And that only becomes a huge thing when we try to terminate. I think Cheryl King mentioned it in a class where, that never really becomes a problem until we try to terminate. And we're like, well, wait a minute, back in the binding, back in the beginning, you failed to do this. So they're now giving you about a day to object. Are there any questions that you have to this point?
Nope, I'm good.
Okay. All right, rules for interpleading this agreement. Oh gosh. Basically just spells it out for you. This, in the event of internal conflicts or inconsistencies, the following rules are this. So absolutely go to your broker, and at the same time, this. Oh, this actually goes into more detail. Oh, this is actually really good. So when you're describing to your buyer why you're not signing things, handwritten changes control over pre-printed or typed provisions. So handwritten or just added stipulations, control over the pre-typed. Exhibits control over the main body of the agreement. And special stipulations shall control over both exhibits and the main body of the agreement, which is why we got to be very careful when we type these up. Notwithstanding the amendatory clause in any FHA shall control over inconsistent provisions. And then it talks a little bit more about agree that the further agreement pertaining to a mandatory clause section does not conflict and is not inconsistent with the mandatory clause. There's an amendatory document that's required to be signed when using the FHA loan. Interesting. All claims or nature whatsoever against the broker, whether asserted in litigation or arbitration, must be brought within 2 years of the date. Survival of the agreement. Following shall survive the closing. Obligation of a party to compensation, the warranty of the title, written representation of the agreement. Buyer's indemnification obligations arise out of the inspection and the party by the buyer and buyer representatives. Condemning attorney fees, obligation of parties regarding ad valorem taxes, the section on devices and fixtures. That's nice. The section on devices and fixtures survive closing. I talked to a buyer yesterday. He's my seller, and he was he's never really sold a property before. He purchased the property and he was unhappy. I guess he didn't do a walkthrough or something. I did not represent them. But he said that anything attached to the wall they took out. And I said, what? First of all, that's why you do a walkthrough right before closing. But secondly, like this section, the section on devices and fixtures survive closing. Like, can't just take cabinets off the wall. Seller's limit liability for not timely removing items, obligation for which agree shall survive the closing may be performed or fulfilled after the closing. Okay, so stipulations perhaps that have been drafted in there that shall survive closing. Terminology, all the context shall mean the plural, and all pronouns shall mean, okay. Time is of the essence. Banking day shall mean on which a bank is open to the public for carrying out substantially all of its banking functions. Shall mean Monday through Friday except for holidays. Binding agreement date shall be a date. So I think Cheryl had mentioned if a term is capitalized, then it's got a definition. So it's throughout here. I would say read it on your own, but I know we're not. So binding date shall be the date when a party to this transaction accepted an offer or a counteroffer and provides notice. We agreed with that. Broker, license, business day. Business day shall mean a day on which substantially all businesses are opened, shall mean Monday through Friday. So business and banking day are pretty much the same. Client, written brokerage agreement. Closing shall be an event in which the party consummates the transaction. The seller tendered the deed and the buyer paid, and both parties properly signed all documents. Both parties fulfilled other agreements set forth. The closing shall be deemed consummated when the closing attorney confirms to the parties that the closing attorney is in receipt of all the paperwork, funds, and appropriate approvals necessary, and directs the funds to be dispersed and documents to be recorded. All parties acknowledge that the deed will normally not be recorded for a couple of days. Payment of sale process payments may not always be made to the seller on the day of closing due to certain circumstances. Like wiring of funds has been cut off that day. Or escrow. Compensation basically means commission. Customer, when they're not legally being represented by brokers. Day means a full calendar. So this is where that 11:59, your due diligence does not end until 11:59. Taylor, this is different for North Carolina, by the way. Material, oh, here we go. Material relationship shall mean any actual known personal, familial, social, or business relationship between the broker and any other party which could impair the ability for the broker to exercise fair and independent judgment relative to their client. So I know money was involved, was that definition, how I had known it in the past. Like if you're going to be monetarily affected by it in any way, that you have to disclose it. So business relationship makes sense. You're part, and you'll see that on the listings, listing agent is part of the LLC in which owns the property. They have to disclose that. But the reason why they put that on there as well is the listing agent has to disclose it on the listing and the purchase and sale. But this is the opportunity for you as a buyer's agent to disclose if there's any sort of relationship. So I definitely would do that on my family. But as far as like representing close friends of mine, I've never disclosed that. I'm not going to monetarily, except for compensation, benefit, and it won't affect me like that. Okay, this is basically the same thing that is in the listing and buyer brokerage agreements. So again, cyber fraud, agreement not to sue, etc. So that gets us back to, what page are we on now? 9 of 10. It used to be 6 pages, then 7 pages, and now we're up to 10 pages of this. Exhibits. I'm a little quirky and I like to have my exhibits, make sure that you have all this checked off on the left. And I like to have my exhibits go alphabetical order. This is listed in alphabetical order. So it's just nice to have that ABCD. You as a listing agent, you're just kind of glancing down. Okay, I should go through G versus alphabetical soup. And you're just going all over the place, eyes going up and down, trying to figure out how many letters you should be having, such that as you go through the contract, you can make sure that each exhibit is present. So definitely make sure that the left boxes are checked. Otherwise, they're not part of it. Even if it's labeled A, doesn't matter. If it's not checked off, it's not part of it. Special stipulations. If you need to add an additional page of special stipulations, Lord, I pray you don't. Click off this box. If you have more than 2 sellers or 2 buyers, click on this additional signature box. There is a GAR page where it's added. Now I just pulled this from DocuSign, so it automatically put my client's email and address in there, to the DocuSign folder I was in. However, because I have a listing agreement and all of his contact information's in there, I do not have to put their address, their phone number, or their email address on this contract. And I don't, buyer or seller, I do not. Just their full name. When I work with buyers, before I even send them the buyer brokerage agreement, I say, give me your full legal name that you would use in filling out a financing application that you would use, and because sometimes they spell out their middle name, sometimes they use initials. But it's like, okay, if you're filling out a legal document, if this is going to be recorded on a deed, as it will, go ahead and give me that information up front so that we don't have to make amendments later. I have the brokerage agreement in that name. I have the contract in that name. I don't have to change anything with DocuSign. I had a client named Lucky, and I'm like, I know that's not your first name. So go ahead and give me your full name now. This is going to help you stand out from the rest. When I'm a buyer's agent, I absolutely 100% fill out the seller's, the listing agent information as much as you can. All of it's on there. First of all, my name's not Chris legally, so that has to be changed, but my license number is on there, phone number is on there, email address. Now, most often you're not going to know their membership. You'll work with a couple of people enough to know that they're part of Northeast Georgia. So typically you just type that in. And obviously if their listings on Northeast Georgia, I don't always give my address, especially with it being Woodstock. So I don't always put that in there, and I don't always put that on the listing agents either. Just depends on how fast I have to move. The new Navica still offers the office code, or is it the brokerage number? Trying to see if I have a listing anywhere on my desk. It's one or the other that they no longer offer on the MLS sheet, and it drives me bonkers. So I have to ask the agent, hey, what's your, it's either the office code or it's the firm license number, but it has to be filled out. So everything on here on the buyer side, if you're writing the offer, has to be filled out. But again, you're going to really stand out, and it's just professional to go ahead and fill out the other side. If it's on the MLS sheet, use it and fill it out is my thing. And then again, the binding agreement date filled out on this XYZ date. And it has to be filled out by either agent. Cannot be a seller, cannot be a buyer, is an agent that is binding it. So that in a nutshell is the rest of the purchase and sale agreement. So Taylor, since you're my captive audience, what are your thoughts? Did you learn anything? Did you not realize something? Tell me your thoughts.
Yeah, I think just how the contracts are laid out in general, the whole B pertaining to like B1 is A1, and it just goes into more detail that way. I didn't know that's actually how they were laid out. I just thought it was just a bunch of legal jargon after
Oh,
that
wow.
point.
Nice. Nice.
So
You explain that at the buyer agreement or the listing agreement. You're like, hey, the purchase and sale is going to be just the same way. A1,
yeah,
B1. You're like, okay. And then when you get into the C, you're like, half of this is a repeat of the listing agreement, buyer agreement. Okay. But it's nice to know. It's nice to know where it is, such as if a tropical storm comes through and the house is damaged, what happens? And you're like, hey, it's already in the agreement. Hey, it's already in the agreement that the seller has to turn on the utilities.
mhm.
Hey, it's so a lot of that stuff is because I like to be able to, that meme is like, well, per my last email, you could do
Yeah,
that. Per the purchase and sale contract, it's already in there, especially if you have to go toe to toe with an agent. That happens. Hey, that's cool that your seller doesn't want to turn this on. And per the contract they signed, it states in black and white.
yeah,
So a lot of people don't read the contract. Heck, I didn't even realize that 10C was like that. So it's nice to be able to use that as reference for your clients. They know where you're referencing it from. They know that you're not, especially when money is involved too. They're like, do I have to get this done by 6 p.m.? Does this have to be done at X? Nope. Until 11:59, though I like my beauty sleep. Let's get this wrapped up now. And that's another reason why some people will use the special stipulation. All parties acknowledge and agree that due diligence or contingencies end at, 7 p.m. so that we can stop negotiating at 11:59.
yeah.
Um, so yeah, so that's it in a nutshell. We'll go on to exhibits next, and then we'll talk about amendments. And then from there, I can give y'all different scenarios. Y'all can start getting more comfortable with command. get more comfortable with creating opportunities, and then start writing offers. And yeah, that way you can be Speedy Gonzalez pretty soon. And it's not intimidating. Awesome. Thank you so much for your time, Taylor, and please be safe. I will stop the recording.